the next case.
All parties in the matter of Arrington versus Boston. Step forward, please.
Massage therapist Kathleen Arrington is suing former client, retired attorney John Boston, for the cost of her services. John is countersuing for the cost of his services, defamation of character, and for an injury to his thumb.
Miss Arrington, you are a massage therapist?
Yes, I am.
And Mr. Boston is an attorney.
Yes, ma'am.
Are you practicing now, sir?
I'm almost retired. I still have a license, but I don't have any clients at this time.
Okay. Miss Arrington, according to what I've read, you and the defendant entered into a barter arrangement. You would provide him with massage therapy, and he would do some legal work for you, problem that you had with a phone company.
That's correct.
And it is your claim that you performed your part of the service.
Yes.
He did not.
That is correct.
And you are suing him for the value of your services because he didn't perform his part of the barter agreement.
That is correct.
Okay. And Mr. Boston says that you actually owe him money because he did provide services. He worked for many hours on your legal problem, and at so much an hour, he discounted it, so you owe him a lot of money. And in addition, he says that you weren't a very good massage therapist because you damaged his thumb, and he's had all kinds of problems, and he's had to go for treatment and therapy. He has his hand in a splint anyway. So this whole barter agreement didn't work out very well. When did you make this agreement, Miss Arrington, with Mr. Boston, and how did you find him?
Mr. Boston came to me for a general massage when he found that I knew how to do neuromuscular massage.
Do you advertise?
Yes, I do.
Do you have an office?
I use my home, a room in my home.
Okay. How did you find her?
Your Honor, I saw an ad in the paper, the Austin Chronicle, which said, "Enjoy a glass of wine with your massage." My regular massage therapist was out of town, so I called her, and on the 28th of December, had a massage which I paid her $130 for.
And when did you make this arrangement with regard to barter?
At the end of the second massage, on January 4th, we had been just exchanging information on both the massages about what we do and what we do in our life. And I had told him twice that I was having trouble with MCI, that I had a defective phone line. They were not giving me the refund I needed. I had lost a lot of time taken off from my jobs to be there the 26 or 27 times it took to get them out to fix the phone, which was still dead at that current time. And he suggested that we barter. He would take on the MCI problem, try and get the money back.
How much money are we talking about?
At the time, I thought about $800. Mr. Boston said that he could probably get that back, plus some money that I probably was entitled to because I had lost so much work on the 26 or 27 or 28 times they had been to my house to fix the line. So it sounded like something that he could handle. He assured me he could handle it. So the barter began, and we did the first massage in the barter arrangement on January 19th.
Okay. And how many did you do on the barter arrangement?
9 massages, 3 of them were for an hour and a half long on the barter system.
Okay. From when to when? From the 19th of January until
From the 19th of January to the last time he came in 3 times in one day on March 10th. By this time, all I wanted him to do was finish the MCI thing. He was vague about it, and I never heard from him again until he called me around March 20th. No, he sent me a letter on March 23rd saying that he liked me. I'm smart, I'm talented, I'm attractive. Then he said he didn't have time to work on my case because he says if I'm hired by cash clients, taking care of their needs comes ahead of other considerations.
Let me see the letter.
In the same thing, he also suggests an hour-for-hour swap. Not.
Can I see?
I've highlighted most of them.
So, at some point, Mr. Boston, I assume that you became interested in a more than professional relationship with the plaintiff. Would that be a fair statement?
Yes, Your Honor, it is. I was divorced 2.5 years before. I was not dating anybody at the time, and I was looking for a relationship, not necessarily romantic, but just a friend. And we did a lot of things together during that time that were social and not professional on the spot.
I assume so. I assume that that's true. I mean, I've read the letter. The letter is clear that there were some discussions prior to this letter being drafted. Is that right?
I tried to keep it as professional as possible. When he refers to, he took me to dinner, he took me to a cafeteria.
Was your case settled with MCI?
No, he walked out. He never even called
Was
him.
your case ultimately settled?
Yes, they gave me credit for $200 and they disconnected my phone because they were waiting to hear from him.
Well, I don't know that. You have a letter to say that says that?
No,
Okay.
I called him.
Can I see the work that you say that you did? I want to see the work, sir.
Right.
Mr. Boston, listen to me, sir. That is your entire file on the case?
No, ma'am. There's quite a bit of all the correspondence,
assume-
but that's the work product file.
No, I'm talking about the file on the case, sir.
Those are the letters exchanged between the agencies that I corresponded with, that I talked to on the phone, the Public Utility Commission of Texas, the Better Business Bureau of Texas at the state and national level, the Attorney General's Office of the Attorney General of Texas Consumer Protection Division, and then I got the top letter that you have there from their office of the MCI.
Just a second. Just one second. What do you get for a massage?
I get $85 an hour. It depends on the type of massage I was doing on him. It's $85 an hour.
Lawyers get more. But that wasn't your arrangement.
No, it was hour for hour.
Well, your arrangement was you would do massages and you would take care of her legal problem.
Right, I did.
Did you?
Yes.
Okay, well, at least you tried. I mean, there's no guarantee if somebody takes on your legal problem.
May I address the court, Your Honor?
I'm speaking. There's no guarantee, Ms. Arrington, if somebody takes on your legal problem, whether you pay them in barter or whether you pay them in cash, that they're going to get the result that you want. That's different from a massage. Hopefully, if you give a massage to somebody, they feel better. He says he didn't feel better. You want to get the second part of your complaint? You say that you were injured by the plaintiff.
Your Honor, it's a violation of the health and safety code, of the health code of Texas, to overtreat a massage client. Between the fourth day of February and the 12th, she did massages on my thumb. It was hurting me, and I told her. She said, "I'm breaking up calcium. It's going to help." Well, it's become chronic. I've seen 4 doctors. The first one was back when I just got back from a trip to see my daughter in Seattle. That would have been early May or late April. And he said, "Tape it." Then I went to my general practice physician. He said, "Put a cast on it whenever you're not doing something that has to take the cast off, use the cast." And then I went to my orthopedic surgeon, and he examined me, and he wrote up a report of that I can submit to the court.
I'd like to see it. Mr. Boston, you don't expect me to accept this as proof that the plaintiff injured you. You have arthritis in your thumb. That's what people get, arthritis. We all have arthritis. You don't know what time he spent on the telephone finding out who to write to, speaking to someone at the Better Business Bureau, speaking to someone at the Regulatory Commission. You have no idea what that is, and there's no way for me to quantify that. Listen to me very carefully. There's no way to do that, madam. That's what happens when you have a barter arrangement. You were giving him massages, and according to you, you gave him 9 massages, and if you felt as if he wasn't doing work for you during that time, I assumed you would have stopped.
He started asking me for sex, and I didn't know how to get out of it.
You get out of it by saying, "Give me my file back." If that's true, you get out of it by saying, "Give me my file back. I want nothing more to do with you." That's what you do.
Then what do I do about the money he owes me for the massage?
You strike it and say, "I made a mistake."
I brought a copy of what I did on him. I also have...
Listen to me, madam. I am not going to say what you did for him is worth more than the work he put in on your file. He did, in fact, in his capacity as an attorney, perform a service for you. The fact that you weren't totally satisfied with his service doesn't mean that you get the money back for the massages. Just like the fact that he wasn't totally satisfied with the massages that you gave him means that he gets any money back from you. Do I make myself clear? Both of you. You made a mistake. Next time, get paid for your service. Next time, get paid for your service so that you leave us out of it. Thank you very much. Goodbye.